I am one of 4 lawyers in the UA Office of Counsel. Just so you all know, our lawyers that represent UA, UAB, and UAH, yes, we have siblings. There's sibling rivalry, but the lawyers are all actually technically employees of the Board of Trustees. So I sit on campus, but I draw my paycheck from the system. And that gives us a little bit of ability to be very frank and direct with our client and not be so fearful of the direct, frank conversation we just had. We have so many policies to discuss, and I can't even begin to discuss all that are pertinent to you. So I picked the ones that can create the largest amount of legal exposure, or when we talk about FERPA, it's not so much the legal exposure, it's this, you have to know it day in and day out. It's not an occasional, oh, I need to know. You need to know FERPA every single day of your teaching career and as a student. So on this slide, we've got the policies that we're going to cover today. And the first thing I want to do is direct you to the pages that I'm on. We start my stuff on page 53, but I want to quickly get you to just look at one of my handouts, and it starts on page 88. And those are some important UA policies. We're not going to be able to go into all of them, but the very first one is one I want you to remember, because it's going to be a one-stop shop for you and your students in the future to know where to go to get help about a particular problem. You act. Big U, big A, act. See how catchy that is? Because if you know something, you act on it. And the only thing you're going to have to know is, well, who do I go? Who do I call about this particular problem? So we're building this website. It's been up for a year or so. There's going to be some new videos that come out probably right around the second week of school starting. And those are going to be some important videos on what we call bystander intervention. We'd love it if you would offer those maybe extra credit for kids who watch the videos. But they're going to be different scenarios with drinking, with alcohol, sexual assault, dating violence, domestic violence. And the message is, you know, we're all in a situation where we could stop something bad from happening. And so I really haven't even seen the videos. I've just heard about them. The message of the video is step in, intervene as the bystander. And by law, we're required to provide this training, so you're going to hear more and more about it throughout the year, but you will see those videos up on the UACT website. Also, when you go to that website, there'll be reporting channels. So that's the place that you can go if you're experiencing harassment or a hostile work environment, or there's behavior that's concerning to you, that a student has written a paper or is saying things, the F word in class, whatever, and there's a pattern, not just the F word, but there's a pattern that you're concerned for safety. We want you to know who it is that you contact. And so that's a one-stop shop. If there's somebody that you think is doing something improper with financial, maybe getting reimbursed for a trip and you're concerned about that, you can go to that UACT website and they're going to direct you to an anonymous hotline or another person that you can call. So make sure that you know and go look at the UACT website and watch it as it develops. There's a chart I didn't print this time for the notebooks, but it is online and it will be updated, but it's basically, you know, it's color, and it will tell you if you're a student and you're experiencing this, this is the office you contact. If you're an employee and you're experiencing this, this is the office you contact. So the test at the end of this session is, where's the one-stop website to go find out who it is that you contact? UACT. It can't be any simpler than that. One of the other policies that I want to highlight for you, and it's I'm looking for it. It's on page 90, and it's the behavioral threat assessment. Now, if you go to the UACT website and it says you're concerned about some alarming behavior from one of your students or one of your employees or just a third party on our campus, What do? They'll tell you to contact Charles Dorsey, and they'll tell you about our behavior threat assessment. We have a team, and maybe some of y'all are aware that several years ago up at UAH, we had a biology professor named Amy Bishop who did not get tenure, and she ended up coming to a biology faculty committee meeting and shooting and killing her colleagues in that meeting. Horrible situation. We had always done a great job having what we call behavioral intervention teams that would work with disturbed students. And so we have that process in place, and I'll tell you about that in a minute. But that was kind of a new concept in higher ed. We didn't have threat assessment teams for everything else. Well, we do now, and we are so pleased that we have hired Charles Dorsey, who is a former FBI agent who spent years of his professional career with the FBI assessing threat for all kinds of law enforcement. He's right here on our campus, and that's who we use. So he can't do a good job unless we provide him information. And so if you're concerned, but you're, oh, it sounds mamby-pamby, I don't know, I don't want to get involved. No, you send the information on. What you don't know is that there might be 3 other of y'all that have sent information. Charles' job is to connect dots, but if he doesn't have any dots to connect, he can't do a clear assessment of threat. So know that we have a very experienced threat assessor. He's not the only one, by the way. We have a whole committee. So he will pull in UAPD. He'll pull in Lee Keys from the counseling center that you've heard from. If it's an international student that we're having issues with, he'll pull in Charter Morris or someone with international students. We'll pull a team together because the more dots we have, the better the assessment of whether there's a threat. So hopefully in the future we'll build Charles in. He was out of town this week, but I wanted to make sure you knew about him. Now, I also told you we have a behavioral intervention team. That team deals with distressed students. They can go to the counseling center, as Lee Keys told you earlier, but if you're concerned about a student in particular, another avenue for you to use is to contact the director of the behavioral intervention team. So again, if you go to the UACT website, it will get you to Amelia Bomar, and they won't name her by name, I don't think, on there. They'll say the chair of the BIT team, the behavioral intervention team. So again, same philosophy. We've got to have dots to connect to help us figure out. The difference there is they may not be a threat to the community. They may be just a threat to themselves, or they're not doing well and they clearly need some counseling. You want to contact Amelia Bomar. Okay. Let's flip back and let's go on and let's start plowing through. But I did want to highlight those 2 policies. Do spend some time looking at that policy website, because that'll give you some great information about some other policies that I won't have time to talk about. All right. First of all, do we really need to be trained? I put this slide in because I read the Chronicle of Higher Education and Inside Higher Ed every day, and sometimes I feel like, we're just, I'm the little school marm up here, and I'm telling you, don't. And I go, does it really make a difference? Well, when you look at the level of the people that are discussed in the Chronicle of Higher Ed and what they've done, and one came out Friday, okay? Daytona Beach, the president of Kaiser University's Daytona Beach campus. Apparently his car broke down, and he was carjacked and mugged over the weekend while meeting with 2 women for a sexual rendezvous. He's 60, the 2 women are 20 years old. And yes, a horrible thing happened to him, but my gosh, he was meeting with 2 students for a sexual rendezvous. He is suspended pending a thorough and comprehensive investigation. So, are there others? Yeah, I give you some examples. My favorite one is the Tacoma Community College. Anyone from Washington know anything about this one? A former instructor criminally charged for persuading a voice student that she could hit lower notes if she stripped or engaged in sexual activity while she sang. Really? That one's criminal. And There's a million more. I teach higher ed law for the College of Education. There's a million more of the stupid things some of us do. So do we really need to be trained? We do. You'll see one here, a tenured faculty member fired for having a consensual sexual relationship with one of the students. We're going to talk about our policy here. Not a good idea. Another student, this one y'all probably know about from Rutgers, the student was criminally convicted for disclosing a webcam to spy on his roommate's same-sex encounter. So it could be, we'll talk about some exploiting students in our own policy. So there's plenty of examples. Y'all can be entertained with them, and I say entertained. Think of your name splashed across the Chronicle of Higher Education and on some talk show. It's quite amazing. So I've decided, yes, I really do need to train so that y'all don't do that. What are some consequences of violation? As a GTA, when you've signed what's called a memorandum of appointment, and in that memorandum of appointment it says that we expect you to comply with our policies, meet the performance standards, or you could lose your job. And then there's a paragraph that says if the dean in concurrence with the, department chair in concurrence with the dean feels it's in the best interest of the university that you no longer be employed, then you could lose it. Now, we don't just terminate GTAs, we need y'all and we appreciate everything you do. But if you start violating these policies, then there's a very quick and easy process. Because you're like me, I'm an at-will employee, and we can be fired for a good reason, a bad reason, or no reason at all. We don't have tenure, and I'm just like you are, okay? And there's all of our staff are just like you are. But that means we need to know what the policies are, and we need to comply with them. You're an employee, but you're also a student. So if it were really egregious, you could jeopardize your status as a student, and so there would be code of conduct, student conduct sanctions. Also, if we breach some of the policies we talk about, we could bring down the federal government to the University of Alabama for some investigations, depending on what policy. There's a different federal agency for every policy we're going to talk about today. In addition to that, they could sue. We would defend if you've acted within the scope of your employment, but if you blatantly violate, i.e. we've told you not to have consensual relationships with your students while you're have any kind of authority over them, and it's not just the grade, it's any kind of authority over them, you cannot date your students. So if you did, and then that student said it really wasn't consensual, I felt I needed the A and I needed to do whatever, and that happens, y'all. It really does happen. We would not defend you in that lawsuit if it were brought, and you would have to pay for your own legal defense. So it's not a standard of perfection, as you heard earlier. We're all going to mess up, and the good news is our office will step in and help defend you in any action as long as you've acted within the scope of your employment. But if you blatantly violate policy, then we're not going to be in a position to defend. Cost and disruption of litigation is tremendous. I just left another training session with a faculty member discussing how difficult it was to provide an accommodation in a particular situation. And yes, I agree, it's frustrating, it's time-consuming. However, on the other side, if we didn't do it right and then we're in litigation, they're going to be even more mad because now they're going to be in our offices prepping for depositions, having to give me every email, every conversation they've ever had. We're going to spend hours upon hours. Kathy's worked for years with me with investigations. It's very time consuming and it's disruptive. You're now pulled aside and you're, the question earlier I heard about how do you balance your time, I've just blown that out of the water because I'm going to want you full-time paying attention to this legal matter. So you don't want to be in that situation. And the good news is since the grad school has allowed me to come and talk, we rarely get a lawsuit involving a GTA. And the two that I can think of, both of them missed the training. Okay? So there you go. One was a potential sexual harassment, and the other one was a violation of FERPA and the ADA by discussing in front of an entire class what a student's accommodation was and what that professor thought or that GTA thought about it. And She was from overseas, didn't realize the rules in America. She missed the training session. So if y'all just listen and realize you've got some great resources in your handbook here, you're not going to be in that situation. So thank you, grad school, for giving me these minutes to do that. Obviously, the reputational damage, you don't want your name on the front of the Inside Higher Ed or Chronicle of Higher Ed, Twitter, Facebook, or wherever else. Okay, so I've already talked about the UACT website, so we're going to just go on to the next slide. University does have a non-discrimination policy, and you know, for years we had sex and then we had sexual orientation, and we have very clearly added gender identity and gender expression. So I just wanted to highlight that in our non-discrimination statement. We've always protected that, but we had to wait really until the law was a little bit more clear, and it's very clear now that that's covered. It may not be by Congress, but all the agencies that provide money to us say it is required. One thing I want to point out, and this comes up more in the summer, but some of you all may be working with students or children who come on our campus who are under the age of 17 or under. So if you were to learn of child abuse or neglect regarding someone on our campus, 17 or under, or involved in one of our programs if it's off campus, and you learned of that, this is one of those where you are a mandatory reporter, and you have to call UAPD. Don't try and figure out, does it meet the elements or not? Just report it, and then you're done. If you don't report it under Alabama law, you're guilty of a misdemeanor. So this is one of those, put a star by it, this is one. You are a mandatory reporter for child abuse and neglect in Alabama. That means 17 and under. Also, just want to point out, if you do that, I know I've had actual employees telling me, well, I'm afraid that they'll sue. Don't worry about it. We'll defend you. And actually, in the Alabama statute, you have complete and absolute immunity. I can get you out on a motion to dismiss. Don't have to have your deposition. It's very quick. So err on the side of reporting and let the police do their job. Also, if you do that and somebody attempts to retaliate because you brought the information to the attention of the UAPD, per our policy, you are absolutely protected from retaliation. Okay? So let's get into some of the issues that are of greatest concern from the legal perspective. It's coming down from Department of Education, and that's a lot in the area of sexual assault, sexual misconduct, dating violence, domestic violence, stalking based on gender. Tremendous in the last since 2011, tremendous obligation on the part of universities to do something about the sexual assault, dating violence, domestic violence, and stalking. And just this year, we've had to implement some new changes to a policy. I called the Chancellor's office today because we have a new sexual misconduct policy. I'm going to give you websites of where it's located, but it's not up yet. It's still getting approved in the Chancellor's office. It's been approved by the President, and everybody, a million people this summer have been involved in that process. So I'm going to tell you about what's in it, and some of my slides, because they were due July 1, are a little bit different. They're not what you're going to read in it because there was some editing, but it was the best we can do. For some of y'all coming next week to the Arts and Sciences training, those are more accurate because I was able to turn those in last week. So let's plow through some things that I know aren't going to change. In the Code of Conduct, you know what, Kathy, I just noticed that thing just stopped, so I have no clock here because it's very different from my watch. I've got one. Yeah. Okay, Code of Conduct says, if you're a student and you violate any of this laundry list of policies, actually it's any policies, sexual misconduct, hazing, harassment, the child protection policy we just talked about, the drug-free campus and workplace policy, and an alcohol and drug policy. Y'all, don't bring coolers of beer into your class. I know you're laughing. It happened here. They didn't realize. You can't do that. You can't bring beer or alcohol to your class. And I would suggest don't drink with your students out at the bar after class. You're just setting yourself up for horrible allegations that we've had to deal with because accusations are made about what somebody did while they were intoxicated. So we've got a policy on that, and as a student, we could sanction you as a student, and you could lose your GTA position. Is it working again? Okay. Okay. I need a big clock. Dangerous weapons and firearms. You can, students cannot have guns on campus. You have to check those into the UAPD. Employees are not to bring them into the building, but if they have a proper license, whatever, and it's in their car, they're going to be okay. I just want to mention that because that's fairly new. Okay, so if you have a code of conduct problem, and we're going to talk about sexual misconduct in a minute, but if you have a code of conduct problem, how does that work? Well, any of y'all, any member of the university community can bring a complaint against a student for misconduct, and you make that complaint in writing and you bring it to the attention of the Office of Student Conduct. Todd Borst is the director. And is there a statute of limitations? Well, the faster you get us the information, the faster we can act on it. And you know 2 weeks later, you're not going to remember it the same way. So the longer you wait, the less likely we're going to have good, clear, concise, uncontradicted facts. So we say in here, preferably within 1 month. I don't think you should wait 28 days if you've got a code of conduct violation. The F word issue you heard about earlier, and just smarting off in the class, if that continued, I would turn them into the code of conduct folks and file a complaint. You know why? Because, you know, obviously you're talking to that individual one time, didn't work. And so that means there's probably something that they need some help with. We're not a criminal court over in the code of conduct. We actually have all kinds of resources in place, but you got to get to the code of conduct so that they can help the student learn that that's not what you say in class. Most are going to get it, but a few are not, and that usually means they need some help, and that's your kind way of getting them some help, is turning them in. The student code also has, again, this is not a gender-based, it also has a harassment endangerment provision that says, hey, look, if you're just bullying people, doesn't matter that you're not bullying based on protected status, age, gender, race, whatever. You're just being mean. You're invading somebody's privacy. You're basically stalking them. You're putting stuff on social media, and they could be doing this about you. There could be consequences under the code of conduct. So I wanted to point that one out. But now we get to the sexual misconduct policy. All right, so Title IX is the federal statute that says federal government is going to give the University of Alabama a bunch of money for federal loans, et cetera, federal grants. It's what we need to keep operating and for all of us to go to school on. And we're only going to give that to you if you promise, University of Alabama, that you're not going to discriminate in the benefits on the basis of gender. That's all the statute really says. But from that, the Department of Education, through its regulations, has made our response to domestic violence, dating violence, sexual assault, sexual exploitation, the whole list, has made that very much a part of the national agenda, and that we're responsible for making sure that if that happens, that we provide adequate accommodations and resources to the complainant. We try not to use the word victim, and that we give adequate due process to the respondent, the person accused, so that we have a fair process and we act promptly and appropriately, so to give that due process, if it's a student who has been the respondent or the perpetrator, we're going to take them through the code of conduct process. Okay? If it's an employee, we're going to have a lot less of a hearing. We're going to have an investigation, and then we're going to make a decision. And so that employee would have a chance to tell their story, but it's not going to be a whole hearing panel. It's just a different process. This sexual misconduct policy covers the process for both. I give you the laundry list of things that could fall within that. It's going to be any gender-based discrimination, harassment, and we'll start with sexual exploitation. Unfortunately, we've had situations where there might have been consensual sex, but then somebody taped it and then it went viral. And there was no permission for that. You know, a kid's going to get expelled or suspended for a long time for something like that. Allowing a third party to observe sexual acts if there's been no consent for that. Causing someone to get drunk for sexual purposes, that's going to be a very serious kind of policy violation. Sexual assault, I'm not going to read this slide. I'm just going to go on to the next. This is really one of those slides that's changed as we edited definitions, but realize that is very much a big part of this policy. Another part of the policy is the Department of Education said, you know what, colleges, you're not explaining what consent means. And it's really, I'm glad I'm married and settled. For those of y'all still maneuvering all that, I mean, our kids are coming to school and they don't understand this concept, and they could get quickly in trouble, and it's usually our freshman population. And they'll be out and they'll be drinking at some of these early parties, and things are going to happen, and there's a lot of misunderstanding of what somebody gave permission for. And so our policy now makes it very clear that there's got to be a clear willingness to have engaged in that act. And you may have given permission up to this point, but not beyond that. So there you go. I think this is hard for folks to maneuver. So you didn't give permission for the next step, so you could be charged with sexual assault, because even though the permission was to do this and that, it wasn't for the next step. That's where we are in the law and with the Department of Ed. And so the Title IX coordinator's office, the Code of Conduct, or our harassment officers, we're in the situation of trying to figure out, was there consent or not? So if any, you know, as you delve into this, there's going to be a lot of training on that bystander intervention on the UACT website that's going to talk about trying to help our students understand you cannot engage in these behaviors without consent. And then it's got to be very clear consent. What do we do? And here's one of those ones that I want you to star, because this is the bottom line. What do you do if you know about it? I just left a training session with a faculty member asking our Title IX coordinator, hey, I overhear students talking about what went on the weekend and how upset they are regarding a sexual assault or a dating violence or domestic violence. What do I do? Beth's answer, and Howard is our Title IX coordinator, was, hey, they may not want to come forward, and the Department of Education says we have to respect that privacy, but shoot me an email. Send the Title IX coordinator an email and tell her what you heard. Why? Because under the law, the Title IX coordinator's job is to make sure that we're aware of every possible situation. Even if I have a victim who doesn't want to go forward, I may learn that it's the third complaint about a particular organization or a particular person, and what Beth Howard will do is she'll draft an email for you to then send out maybe to your students to remind them about the resources that are available, or that will clue in Beth that, hey, this is the third time with that organization. I think I'm going to invite myself to go do some training. So nobody's in trouble. We're just going to educate. So pass on information. What I want you to let them know is that if it's a crisis situation, let's say we're dealing with rape, there's free rape kits over at DCH. Nobody has to pay for that. And if they think they're going to criminally prosecute, we have to tell you, get the rape kit and preserve the evidence, okay? Most of our students don't want to go that route, but you need to let them know UAPD is the first stop if you want to prosecute. Second, there's a Women and Gender Resource Center, formerly known as Women's Resource Center, but we wanted to make sure everybody knew that center deals with gender-related issues. So this is right up the ballpark. This is what they do. They help provide counseling. They have victim advocates. And here's the beauty. Anything that they know, none of the rest of the university gets to know. This is the truly, strictly confidential source where you could send a student for help. then they'll get on the phone, the Women's Resource Center, Gender Resource Center, and they'll start helping the complainant get the resources, whether it's calling you all and saying, hey, I can't really discuss what's happened, but so-and-so missed your exam today. If you get a call from the Women's Resource Center, it's probably likely something has happened, and we're going to be asking you to provide an accommodation, come up with a different test day. You can always call the Title IX coordinator when you get a call like that and you're not sure about what to do. But the reason why they're calling is by law we have to provide accommodations to help even if they don't want to pursue, they do not have to file a criminal complaint, they do not have to file a complaint through the Code of Conduct. Our job, according to the law, is to make sure that they can continue on and succeed, even though the University of Alabama had nothing to do with the incident. That's a huge change in the law for us. So let students know that they have a confidential office. Now, if it's not the Women's Resource Center, you can contact the Office of the Title IX Coordinator. Now, once the Office of the Title IX Coordinator knows, or once our designated harassment resource person knows, we're on notice. And then there's a bunch of legal responsibilities. You don't have to worry about those. We do. But once the Title IX Coordinator knows who the complainant is, what will happen is Title IX Coordinator will send an email to the complainant and say, hey, I heard that you were talking to Professor so-and-so. I want to be able to meet with you as quickly as possible so you can know what your rights and options are. So it's not a scary thing. It's really all designed to help get help. And then if they want to pursue, then we've got quite a difficult job of providing due process to both parties. Actually, 50% of the lawsuits right now are not by the complainants. They're by the accused, saying that the institutions are rushing to judgment. So we're taking this very seriously and trying to do everything we can to be as fair as possible through a process. So your job is to know these resources, okay? So the next slide just tells you a little bit more about Beth, where she's located in Rose. She is moving over to Mary Burke Hall, where the Code of Conduct is, probably by December, but for this semester she's still in Rose. There's a Title IX website. If you go to the UACT website, you'll take it. They'll link you to that. So that, again, don't forget the UACT one-stop shop. All right, so that was about sexual misconduct. Now I want to remind you that we also have a harassment policy. It applies to students and faculty and GTAs and all staff, and it basically says we're not going to tolerate behavior that is designed to harass or create a hostile work or learning environment if it's based on, and I'm going to go on and get to this next slide, yeah, right here. If it's based on race or color, religion, ethnicity, national origin, sex, which is Title IX, we've already covered that process, age, disability, or protected veteran status. If somebody's picking on or making life difficult for someone because of these protected characteristics, then our policy says we're not going to tolerate it and we're going to do something about that. Let me go back one slide, make sure. We have some definitions within the policy, and for you as the GTA for your classroom, guess what? You're the supervisor in charge of your classroom. So if this is engaged, if this is occurring in your classroom or in the not study groups, other studios that you might have, or a lab setting, it is your responsibility to stop and get help to stop it from occurring in the future. There is, at the UACT website, and I give you the direct website here, every college has a designated harassment resource person, okay? They're trained to know what to say to a complainant, what to say to the respondent. Your job is to know that if this is happening and it's not gender-based, go find out on this website who in your college is your designated harassment resource person, and that's who you want to direct the complainant to. Our policy also, I'm going to skip to that because I'm watching my time. Well, let me talk real quick about Facebook, because I saw in your handbook that you have a great piece. I'm not sure who authored it, on how to use Facebook and engage with your students. And that is awesome. And that is the way you are engaging them. The problem that we've run into with GTAs in particular is they want to be everybody's friend. And so all this junk that's your private business, when you're directing students to your Facebook because you want them to engage in conversations or whatever and help the learning process, but you have a bunch of inappropriate stuff. Think about it's as if you just put it on your chalkboard in the old days and you're right there in the classroom. We've had to terminate GTAs who had very inappropriate stuff, and it was almost as if they were trying to get the kids to look at that rather than teach them. And you'll lose your GTA in a heartbeat if that's what's going on. We are not trying to be violating anybody's free speech rights at all. And so we're very careful to examine that when it's brought to our attention. But the bottom line is you can be disciplined. And remember, you're like me, the at-will employee. I can be fired for a good reason, a bad reason, or no reason at all. If I've done something stupid, I'm probably not you know, I've been here 26 years, so I haven't done something so terribly bad to lose my job. But I'm just saying, y'all don't push the envelope. Don't push the envelope. Confidentiality. We have confidentiality in our harassment policy in anti-retaliation. We promise confidentiality to the extent we can keep it, okay? So if you tell a designated harassment officer something, we have a legal obligation to do something about that. So we're only going to tell those who need to know. Sometimes the complainant doesn't want the accused to know. And so now, under the law, we have to say to the complainant, that's great, tell me as much as you can, but I'm going to have to do something to stop it. And I also have to comply with your request to the extent I can. But if you're the fifth person in here with someone who's, you know, doing something really, really bad, either racially or sexually or national origin or religion, whatever it is, and they're creating a problem, we're going to have to move forward. But if you absolutely won't let us tell, then you're really limiting what we can do. I'm just saying there comes a point in time when we have too much knowledge that we're going to have to move. So that's the kind of conversation that the designated harassment officer is going to have, not what you're going to have. That's why you want to get them to people who are trained to have the conversation. It's also against the law to for someone to bring forth a complaint and then for anybody to experience retaliation as a result of that. You're absolutely protected. If you're a student, you know, you can't have your grade lowered or put off in the group that nobody wants to be in, or a faculty member saying, I'm not going to write you a reference letter because you filed a complaint. If you made that complaint in good faith, you are absolutely protected. For employees, you can't be demoted, reassigned, you know, not get a salary raise, whatever. Okay, I mentioned that we have a consensual relationship policy. We are not the love police. We want you to fall in love and be happy, but not with your students that you teach. We can handle if you have a spouse in the same program and they're going to have to enroll in your class, we're going to do everything we can to manage the situation, but we have to know about it. Okay, so that means they may sit in the class, but somebody else is going to do the grading. My best advice for y'all is, you know, save the name and number of the student that you are starstruck, and, you know, and this is it. You know, this is the divine appointment of the spouse-to-be forever. Save it, and when you're all done, grades are all turned in, and you're not going to teach them again, that's when you can, you know, I don't know, ask out for the date, whatever. It's been so long since I've done that. But the point here is we don't prohibit students from dating faculty members. It's just we can't have it if there's some power differential. Okay? Is that pretty clear? Okay. Hostile environment or academic freedom. Many of y'all are in the arts and sciences arena, and you're going to talk about stuff that can really rock the world of some of our students. that have been raised in a very conservative environment, and our job here is to be the marketplace of ideas and expose our kids to thoughts they've never heard before. And that can be upsetting to some of our students, but nonetheless, we're not going to water down the marketplace of ideas. You have academic freedom rights in the classroom. The problem is how do you know when you've walked over, you know, when do you have academic freedom and when do you don't? This is a good case example of a professor from Maycomb Community College. He was an English lit professor, and he was teaching a class and had been warned previously about extremely vulgar language in his classroom speech. But and he had permission to teach sexually explicit literature. That was within the course genre and part of what he was teaching. But what he did is he then started talking about his personal sexual escapades, is what they said in the courts, in the case. He ostracized students who expressed offense or disgust, and he frequently used obscene and vulgar language. So he was disciplined, and then he sued. Get it? You know, it always amazes me. He sued because of what he made his students go through, and he got penalized for it. And the Sixth Circuit absolutely upheld the university's discipline, saying that students are a captive audience paid to be taught and not vilified in indecent terms, particularly when there's no academic purpose or justification. So basically, you've got academic freedom, but you can't compromise the student's right to learn in a hostile-free environment. The key here, and it's really in the next slide because our policy is written based on that case and some other guidance, you've got to tie it, that last bullet here, you've got to tie it to the subject matter. If it's germane to the subject matter, fair game. If you're teaching math, there shouldn't be a discussion of sex, okay? That biology, well, maybe biology, chemistry, there's common sense, y'all, and if you have any questions about whether you're pushing the envelope, talk to your authorities within your department, not other GTAs, experienced teachers. Okay, so that kind of takes us through the harassment policy. We also have a hazing policy. Again, on the code of conduct, this could create a problem. This is when you're making kids do things to be part of an organization, and there's a whole laundry list of things that could get you in trouble. And actually in Alabama, and little of us really paid attention to this until recently, but it's a crime for you not to report hazing if you know about it. So bringing that to your attention. If you know it's occurring and you do nothing to stop it, or you fail to promptly report to UA authorities, or if you retaliate against the person who reported, that's a problem. I'm going to skip this next one because I'm running late, running behind. 1:45, I have 30 minutes, yeah. Students with, all right, let me stop here and let's handle questions, if that's okay. Lisa, are you around? Let's handle questions on just what I've talked about. We'll say just students with disabilities, and let's hear what you got. If there are any. If there's not, that's fine, we'll plow on. Any questions? We've got one over here. Is there one on this side while we're waiting to get over there, and there's one in the back?
So is the standard, sorry, I'm in the back. Is it the standard operating procedure then to report but not to engage students in all of these? Because you said for sexual harassment.
Yes.
It's, okay, so.
Thank you, thank you. That's an excellent question, because I'm glad you brought that question up. Across the country, there's this huge debate. Should faculty be deemed, if faculty knows something, and GTA, you're faculty in this context, if you know something, is that notice to the University of Alabama? Right now, our sexual misconduct policy, the way it's written, if it's approved by the Chancellor's office, says no. Faculty and GTAs, you are not what we call responsible reporting officials. Dr. Pagani will be, every department chair will be, student organization advisors will be. There are certain people. But we also recognize that students are more likely to talk to you, okay, than maybe to someone else. That's why we don't want you to be the the notice to the institution, because I don't know that I can train all of you that well. There's all kinds of regs, and I don't have time to train you on that. So I want you to report it to someone who is trained, okay? But I'll tell you that if you're at a different institution, and you've come here from a different institution, we are taking different approaches. And right now here at UA, we're taking the approach of we want you to report and let the people in charge know, but we also want you to have students feel free to come talk to you. But I don't want you engaging in all of this. What I want you to talk about is, hey, the Women's Resource Center could really help you, and I really encourage you to go there. Or I'll get on the phone with you and call Beth Howard, or hey, I'll help you send the email. You know what I'm saying? You're facilitating the person getting to the right person. You are not trying to handle the investigation or anything else. Question, next question. I thought there was somebody over here. Nope, we'll go on. And I'll stay afterwards too. All right, students with disabilities. There's some FAQs that I'm going to tell you are going to give you a little bit more detail, and they start on page 81 that tie in with my slides on this, okay? But before we, well, we're not really going to go over each of those questions, but I just want to give you the legal reason why you have to pay attention when you get a letter from the Office of Disability Services that says you've got to accommodate. So under the law, and you could say employees too, because you all are employees, so when I train y'all, I love it because I'm training you as a student to help you know your rights, but I'm also training you as an employee, and you're the agent of the university, and so you're responsible to know some of this stuff, okay? So dual roles, students and employees with disabilities who are otherwise qualified must receive reasonable accommodations and are protected from discrimination, harassment, and retaliation, okay? So the Americans with Disabilities Act requires that, and then what we call Section 504, the Rehab Act, long ago passed. I won't go into all that. So that's the law that we're trying to comply with. So who determines whether somebody has a disability? If you're dealing with a student, the office that is in charge of figuring that out, it's not the legal office, it's not the graduate school, it's the Office of Disability Services. If you're an employee and you have a disability that we need to accommodate, then you're going to be contacting Human Resources, Emily Marbutt, M-A-R-B-U-T-T. I don't have a slide on that here, but we are required by 2 different laws to provide that accommodation. So professors can't decide it, your supervisor can't decide it. Y'all aren't even supposed to know what it is. You're just going to get to know what the accommodation is. So don't try and self-diagnose. I've had really nice professors get on web, Google, and try and figure out based on what's happening with this kid in their class, and they come with a self-diagnosis, and I'm going, no, because now if you give them a C or a D on their paper, you know, after you've self-diagnosed and they're not happy, they're going to say that you did it because you perceived them to have a disability. And that's illegal. You can't perceive someone to have a disability and then treat them differently because you perceive them to have one. So stay away from diagnosing. Just have somebody get them to the right office, and then let others who are trained do their job. Now, the Disability Services Office, if someone has produced documentation that they have a covered disability, will generate an accommodation letter, okay? And you don't get to know the disability, you just get to know what accommodation you have to provide. So what I would recommend to you is when you get that letter that you sign, make a note of when you did that, because you're going to have situations where students come mid-semester. Some of our students, they want to try so hard to do it without the accommodation. And then halfway through the semester, when it's not looking good, they decide, okay, I'm going to give the letter. They've already been to ODS. It's just stigmatizing to them, and they don't want to do it. And that's their right. But then they come to you and they want to kind of do a do-over. Nuh-uh. They don't get a do-over. The accommodations start when you get the letter. So for your own legal protection, document when you got that letter. And that's just a good practice so that there's no factual debate as to when that letter hit your your knowledge base. Okay, so we said you had to be a student, and then you have to be otherwise qualified. And what that means under the law is that we don't have to accommodate everything at the University of Alabama. We only have to accommodate if the student can meet the essential functions, okay, of being a student. So we can set GPAs and ACT standards. We don't have to lower our academic standards. If they can't meet them, they're not otherwise qualified, so they're not protected under the law. If you've got an attendance policy and there's a good educational reason and you consistently apply it, we can work with that. And that's an educational decision, and we're not going to have to accommodate it if it's deemed to be an essential function. But if you're giving out, you know, oh, that's okay, you missed class, and excuses, even though your policy says X, but you're actually operating Y, we're going to have to provide an accommodation to the student who couldn't make the class. Even though your policy statement was clear, in practice you weren't operating that way. So I'm telling you, you've got freedom to set it, but then stick with it. No exceptions, and then that's fair game. We also don't have to allow our students to cheat. There's actually a litigated case where a student plagiarized and blamed the plagiarism on their disability. Well, I'm sorry that that's what caused it, but you're not otherwise qualified, because part of being a student at the University of Alabama is you're required to comply with our code of conduct. And if you can't meet our academic misconduct policy and our code of conduct, you're not otherwise qualified. So we don't have to accommodate a cheating disorder, okay? And then the most important one, we've talked about it right off the bat, the behavioral intervention team. We do not have to accommodate someone who's going to threaten the health or safety of others, okay? So if someone is scaring us, you need to let Charlie Dorsey know with the threat assessment team, or Amelia Bomar with the behavioral intervention team. We do not have to accommodate. I don't care why the person may be a safety risk. Under the law, we don't have to worry about that. It's the conduct, and it's fair game. We don't have to accommodate that. Okay, so you got a disability and you're otherwise qualified. What's our responsibility? Our responsibility is to provide reasonable accommodations. That may mean architectural barriers, ramps, special chairs, special computers with large screens, whatever. We may have to provide some note takers, and I'll talk about that in a minute. We may have to provide just slight modifications of your classroom presentations or your testing. You're going to run into that. They're going to need time and a half on a test or a distraction-free testing environment. We'll talk about how we can do that. But those are reasonable accommodations, and that's the kind of stuff you'll see on that letter from ODS. So let's say under the law we've made it that far. Can we deny it? There's very rare circumstances if we've made it that far in the analysis. You have a disability, you're otherwise qualified, a reasonable accommodation's been asked. The only time we can deny that is if it would fundamentally alter our program or it is so expensive. You know, they'd need to have a special building with no access by anyone or whatever, ridiculous, you know, totally, you know, $1 billion. Well, our budget is so big at the University of Alabama, we're not going to ever have unreasonable costs to the institution or to the administrative burden. Y'all have back-to-back classes and you have to provide time and a half and you can't possibly do it. It's still our legal obligation. So we help you out by you consult with the Office of Disability Services in your department to help figure out how you're going to meet the requirement to provide the accommodation, even though it might be a burden on you. That's not a legal defense. So tips, and this is what the handout really goes through, and I'm just going to highlight it real quick. You don't get to decide whether there's a qualifying disability. Make disability services do that. And for employees, again, that's Emily Marbut in HR. You generally don't have to provide an accommodation unless you have the letter from ODS that spells out what those accommodations are. Please avoid this lawsuit, which was the one I mentioned earlier. We had the GTA who wasn't trained yet. Don't discuss accommodations with students in the, you know, I can't believe she did it, but it was right there, you know, in front of everybody with the mic on and almost intentionally debating whether or not that was a fair accommodation. Don't do it. Respect the student's privacy. Don't ask them about their disability. You have no legal right to know that. You don't need to know it. You just need to know this is the accommodation, and now get busy and let's figure out how we're going to provide that. You do want to talk to the student about how we're going to get that accommodation met. The law says it's a collaborative process. I do include, I encourage you to put on your syllabus a statement about, hey, if you're a student with a disability and you need an accommodation, here's who you contact. So I've got you some sample language on page 81 in the FAQs. So if you don't have that on your syllabus, I suggest you look at that. Don't ignore recommended accommodations because you disagree with them. If you're sued and we told you to provide it and you didn't provide it because you disagree with it, remember I said you're going to have to defend yourself? You're going to have to defend yourself. But if you're seriously in disagreement, call ODS. And then there's a process. We have an appeal process that we can go through. So it doesn't mean, you don't have any input. It just means don't push the envelope. This is a serious law and there's lots of damages involved if we don't do it right. And if you are in debate with ODS about it, while that debate's going on, you have to provide the accommodation. There is a new way in which students can take tests through the disability services. They've just moved to Hauser Hall, and so the great thing about that move is we have 50 spots at one time to do alternative testing for our students. So the way they're doing this, and this is new, is students are going to schedule their test over at that location online through this clockwork test scheduling, and once they do that, the instructors will get an automatic email from ODS testing 1 week in advance of the test. Then you log in and you get your instructions there. If you've got questions, there's a tutorial that I give you the website to in the FAQs. Make sure you go through that if you have somebody who does need distraction-free or time and a half testing, and they're planning on doing that in the new testing offices with ODS. Also, new thing in the ADA law is service animals. People may come into your class with a dog. They cannot bring any other kind of animal, just a dog, and a miniature horse to be technically correct. But we haven't run into that yet. But no cats, no parrots, no ferrets, no squirrels, whatever. But they can bring a dog into the class, and in the old days, we would have told you, and they have to have an accommodation letter from ODS. No more. The ADA was amended so that people can bring service animals and not get, they don't have to provide a bunch of documentation. So there are 2 and only 2 questions in the regs that you could ever ask, and again, you don't want it in front of the whole class. Is this dog required because of a disability? Notice not what is your disability, and what work or task is the dog trained to perform? That's it. That's all you can ask. If you do anything else and they want to complain about it, we could have the Office of Civil Rights with the Department of Ed on our campus. And by the way, they're just finishing up an investigation at UAH. We have a question in the back about the service animal. And someone, did y'all see? No, the dog does not have to be wearing a vest. We encourage some kind of marking, and we encourage you to encourage the student to go talk with ODS about the service animal, because the more people who know about the animal, the less hassle the student is going to have, because we can run some interference on that. But they do not have to. You're saying a little vest, or yeah, saying I'm a service animal. No, they don't. We would like them to, because it'd make your job easier. But just know there's 2 questions. And then you can pick up the phone and call ODS and say, hey, I had a student in my class. I want to make sure I did the right thing, and handle it that way. I know there's what's the question right up front? Where, yes, great question. Small class, one's got allergies to dogs. This comes up in housing, by the way. We're going to have to figure out a way to accommodate it. It may mean that somebody's going to move classes. We don't know yet. We're going to be thinking out of the box. It's a real problem, but we have to know about it to help solve it. Okay? Question in the back again. Yes, excellent question. There's some... you do not have to, and this is actually spelled out in the FAQs, okay, so in the 80s, whatever page that is, when I address that, you do not have to allow a dog who's out of control, the handler has to be able to control the animal, okay? So you do not have to tolerate a barking dog, a dog that's really creating a lot of disruption. Now, you need some assistance maybe with ODS if it's repeating itself. Also, there are certain areas on campus, some of y'all are in labs, where we are not going to be able to allow the dog in the lab. So if you work in one of those areas and you know that a service animal has presented a student with a service animal, then contact ODS or read a little bit. We actually have an animal assistance policy. It's not online yet, but we've spent a lot of time this summer updating that and trying to get the rules out. But, if they're pooping in your class, then that means they're not housebroken, and that's a fair rule that we can make them comply with. That would be an awful situation. I have never gotten these kinds of questions about the dogs, ever. Anyways, I could talk about this forever. But anyways.
There's another question.
Yes.
Sorry. I just have a little bit of experience with them. Are we talking about strictly service animals, or are we talking about ESAs? Because an emotional support animal.
Great question. I don't train about that in here because you're not working with housing. So here's the rule. She's raised a really good, there's some animals that are by law through the Fair Housing Act, if in your living arrangement, that you are legally required to allow them to bring an emotional support or therapy. They're not trained to do a specific task, but just having the animal emotionally is important to the individual. Is that?
For like anxiety, depression, some of them
correct.
Are used for that.
So if it's not a service animal who's trained to do something, then we're not legally required to allow that dog in the classroom. However, if they're in our dorms, we are legally required, but there's a different process. And I wasn't going to train you on that because y'all don't work for housing. Our housing people have been very well trained on that.
So you're looking for specifically psychiatric dogs and those trained to complete a physical task.
Correct. And it's so fascinating, and you may know more about it, but I mean, if you're, your seizures, it's not just the blind student with the service animal. They may be able to, I don't know all the technical, but they may be able to smell like when the blood sugar drops or whatever, or an autistic individual who's about to go into an anxiety attack. They're very helpful. What we have to figure out is, are they a service animal or one of these emotional support where it's very technical. I don't need to train you on that. It's too technical and very complicated in my mind. But know that there are people here on campus in disability services. Katie Thompson in our office is kind of an expert on it, and we'll deal with that. Did I have another question on dogs? Yes?
Mine is not about dogs.
Oh,
it's an
okay.
accommodation question.
Yes.
If a student gives you ODS paperwork and refuses the accommodation, can we make them have the accommodation?
No. No. You don't want to force them to have it. But they're declining it at their own risk, and what I would encourage you to do is pick up the phone and call ODS and let them know, and then you document it, because what you've just done is created your paper trail for if there's a subsequent factual dispute about what really happened. But again, it's their decision. They get the letters, but it's their choice whether or not to seek the accommodation, and you just need to make sure you've got good documentation of how you handled it, when you got it, etc. Other questions about disabilities? One in the back.
So I have something that's come up at a different institution I used to work at, where a student was in the process of getting the ODS paperwork, and in the meantime, while getting all of that done, had a letter from her psychiatrist that she gave to me, basically saying this is what we're working on.
Right.
Didn't have the legal paperwork yet, so I was just wondering what
you want to call ODS, and frankly, the students don't need to be giving you the medical documentation. Why? You don't need to know the disability. You don't need to know that. So what you want to do is say, hey, you need to take this straight to ODS, and then you pick up the phone and call ODS and say, what am I to do? And get help from the people who are trained. That is one thing we don't have on the UACT website. So you've got to remember ODS, Office of Disability Services, and I give you a million websites in my handouts. Other questions on ODS right over there? While you're getting the mic over there, I'll just talk real quickly about our obligation. You know, we've got all these new gadgets and toys and new apps and all kinds of technological advances to teach our students, and those are great. But just like the law says, when we build a new building, we've got to have wheelchair accessible, you know, entrances and elevators and, you know, all kinds of things that have to be thought out in advance before the building is open for business. Same thing with all these new gadgets and toys that are great teaching tools. We don't want to be buying technology that is not completely accessible. And so there is a new office or person on campus who is specializing just in technology, purchase of technology, and it's Rachel Thompson, and I give you her website. Technically, we're not supposed to be putting up YouTube videos without captioning. You know, I violated it every now and then. I've never had a student with a disability who needed it, but what they're trying to tell us now from Department of Ed is we need to be thinking in advance. Don't come at the last minute and pop up a video if you've got a student with a disability in your class who may have needed that to been captioned. You're not giving them an equally effective educational experience if we can't have full access to the technology. So, question.
Hello. Last semester, I had a student who was partially deaf and needed multiple surgeries during the semester to correct something with her inner ear. Obviously, we were more than accommodating in the biological sciences department, but like I said, she wound up probably missing more classes than she made because of it. And at times I wondered how fair it was for the, you know, when does over accommodations make it, you know, that the rest of the students are no longer having the benefit? Does that make sense?
It absolutely does. It's a dilemma we face every day, but the issue here is you're not the decision maker. The Office of Disability Services is. Why? So it takes the risk off of you all getting named in that lawsuit. You're going to have to follow the direction. You can debate with them about that, but you don't, you know, you follow the guidance that you're given by the people who are trained. I couldn't even answer that without sitting in a room with some other experts as we worked through, as you can tell, a complicated legal analysis that you have to go through. And so don't take it on your own. It can be frustrating, and yes, you may have questions about whether it's fair or unfair, but there's some really, really great minds out there that process things differently, and we're going to have to think more creatively as to how we're going to help them achieve their goals, just like everybody else who doesn't have a processing disorder or whatever it is, where our goal is to help them graduate. Okay, and if ODS has said this is what we need to do, there's a risk management aspect of it. There's also following, you know, just the ADA law, and then there's just the wow. You know, when we've had a couple students that have been high needs in ODS graduate, I mean, a lot of us felt really good about. We spent many, many hours, many hundreds of thousands of dollars helping that get achieved, but man, we did it. We got a student graduated, and you know, I mean, there's something really good about that you can reflect on. Will?
I know we have to get to the wild world of FERPA, but we got one more question on disabilities.
Yeah.
If a student hands us ODS paperwork, and which says, for example, they get time and a half on a test, should we make the assumption that they're going to take advantage of that, or should we explicitly ask them, will you be taking advantage of that?
Remember that earlier I said once you get that letter, it's now time to talk. Don't talk in front of everybody else, but say, hey, I want to make sure we do this right. Make sure I do it right. Make sure you do it right. Are you going to be using the, clockwork testing thing? Hey, it's kind of new. I'm not really sure how it works. Let me flip to my page. Or call ODS and talk through. That's the part that the law is very clear on. We have to engage in dialogue. We don't have to do exactly what the student demands or wants as a preference, but we have to engage in the dialogue and make it happen. So yes, it's perfectly, you're required to have that conversation. Thank you for pointing that out. Okay. We're going to fly through FERPA, but I'm assuming that you all know what FERPA is. Confidentiality of student records, and the law that requires this and dictates all our rules on this is the Family Educational Rights and Privacy Act. All right. Why do you want to know it? Because we tell you have to. And the law says you have to. And we want to avoid an investigation by the Family Policy Compliance Office, which is the agency in Washington that regulates this. You want to avoid a breach of privacy litigation. The good news about FERPA is they can't sue you under FERPA, but let's say it was really sensitive information that got disclosed. You know, they flunked the test or they were referred to the code of conduct and you publicized that and you weren't supposed to do that. They might have a breach of privacy tort claim. So you want to avoid that even though they couldn't sue you under the federal statute. And mainly, we used to run around here, everybody keeping their mouths shut and not talking to each other, and that's what caused the Virginia Tech tragedy. If people had had threat assessment teams and behavioral intervention teams before Virginia Tech, that would have never happened. People were afraid of this FERPA rule and didn't realize that you could talk to each other. School officials can talk to each other if you have a legitimate need to know. And you don't have to be afraid of sharing information with the legal officer, with Charlie Dorsey, or with Amelia Bomar in the Dean of Students office. So I want you to feel a little bit more comfortable today that you can talk to people about things that are in the records. There's some other training resources that I give you, and those are you can look at later. 3 rights that people have under FERPA, okay? They have and this, again, dual role. You're my employee and you're my student. So here's your lesson on what your rights are. You have a right to review your education record. You have a right to seek to amend it. If we messed up and you made an A and you earned an A, but it shows a B on the transcript, this isn't the grade grievance process, but if we've made a clerical error, this is the right that you have to get that cleared up. And then this is what we're going to spend our time on. You have a right to limit disclosure of your education records to someone outside the institution, or to third parties who have no need to know. So first, let's figure out what's a record. A record is a file, a document. It can be electronic, paper, a text message, a phone message, anything that contains information directly related to a student, and it's maintained by the University of Alabama. Okay, that's it. That's so broad. But that's anything we're maintaining that has, you know, we could figure out which student it pertained to. Here's the key difference between FERPA and what we know as HIPAA, which applies in the medical world, or the attorney-client privilege. When you go to see your doctor, that is entirely, especially if it's a psychiatrist or psychologist, it's absolutely strictly confidential. Very rare circumstances where that would ever be turned over. You'd have to have a court order. It's very tight. That is not what FERPA is. FERPA didn't give you that Harry Potter invisible cloak. And when you come to school, your parents don't get to know about anything. No, it's just the record. So if parent calls you and says, has Johnny been in my class? And you know who Johnny is and you hadn't seen him in weeks, you can say, no, Johnny's not been in my class. Why? You didn't have to go to your record to tell that answer. You know it. You personally have observed it. Nothing about FERPA protects the conversations or what you've personally observed. And if you can remember that one point, you're going to be able to share a lot more information than you thought you could. Okay, so let's say you are dealing with a record. Now, I've got a question in the back if y'all want to head that way with a microphone. If you've gone to the record, you're probably bumping up against the FERPA. But there's so many other exceptions that we're going to talk about that you're probably going to be able to release the information. So let's talk about those. General rule, the easy one, is kid comes to you and wants you to write a letter of reference for whatever, graduate school for them. Can you do it and go in the record and look at it? Well, yeah, just get their consent. Say, sure, I'd be glad to. Or if they hand you the resume and you rely on that, that's nothing the University of Alabama is maintaining. They gave it to you. Fair game. But if you want to go check and find out if what they've represented on their resume is correct or, whatever, and you need to go to the record to write the reference, then technically you need their authorization. It's very simple. I give Professor so-and-so permission to reveal information from my education record to, UAB for medical school reference, date and signed. Okay, it's that simple. Nothing, HIPAA's got 12 rules or 16 essential elements of a HIPAA authorization. Not so with FERPA. It's very easy. You just get some written permission. You don't need permission all the time. You can release directory information as long as somebody hasn't put a hold, and that's my next slide. So what's directory information? This is it. Each school gets to designate what directory information is. So here's our laundry list of it. Note a couple things. It's not a picture of them. We could choose to do that, but for safety reasons, based on our size, we've chosen not to make a photograph of a student directory information. So if you're going to release a photo of somebody, you get to look at it through, your class roster to help you learn your students. But if you're going to send it to somebody else, you better have a good exception because it is not directory information. But anything else on here, fair game, as long as the student hadn't put a hold on their records. And 99% of our students don't put holds on the records, but you need to check on that before you go out and release even this. So they could ask for a list. If they ask for a list of students in your class, technically you can't do that because the particular class that they took is not directory information. Okay? It just means the university as a whole could release a list of all our freshmen and tell them what their last school was, because that would fit the directory information. Here's, got a question up front. Yes. No, if you're blogging within the, and it's limited to just the students or the only folks, no, that's just like talking in class. And another thing here is we're not maintaining that record, okay? I mean, it's a kind of live thing and it's not becoming a record. I would argue that we're not doing it. 2 minutes. Okay, here we go. School officials, you can only access information needed to perform your job, so don't go looking where you're not supposed to look, and don't share it within. If y'all got roommates and you need to protect the privacy of your student information and not allow your other roommates, spouses, whatever, to have that information. But if you get calls from academic advisors or athletic advisors, you've got, they don't need a written consent to contact you. That's part of we provide that service to help our student athletes, so talk to the folks from the athletic department who want to know about your student athletes. Parents, unless a student verifies or the parent proves that the student is claimed as a dependent on their most recent tax filing, if you don't have that and you're not going to have that, then you're going to need written consent. Except, remember, personal observations, that's not a FERPA record. Also, parents think that they own that right, but they lost that right when their freshmen came to school here. The right belongs to the parent in K through 12. When that student enrolls, regardless of what age the student is at the University of Alabama, once they're our student, the right belongs to the student. So even though we have exceptions where we want to talk to parents, there's no right for a parent to get that information. We know they pay the bills though, and so we want to keep both sides happy. And so we work with students to help and parents to help the parent know, hey, there's a place in MyBama that the student can go on the student tab and they can quickly fill it out, and I'll be able to talk to you about everything in the record. Just work with us and work with your student. The other exception is critical. I don't want to face a suicide litigation or somebody going postal on us when the parent could have known and maybe helped us. There's a health and safety exception, greatly broadened after the Virginia Tech incident. All we have to have is a rational basis for us to think that there is a health or safety emergency, and then we can tell anybody that we need to help us eliminate that health or safety. So don't worry about a violation of FERPA. Do whatever you need to do to help get information. Usually, again, it's going to be contacting the behavioral threat assessment or behavior intervention team. You're not going to be having to handle it, but we can talk to parents, roommates, law enforcement, teachers, mental health professionals. There's this exception that allows us to do that. So, one question in the basket. In the event that we are asked to testify under oath with regard to something related to our GTA activity, does the Office of Counsel represent us or UA? Yes, we do. We will represent and help you. Katie Thompson in our office is now handling the subpoenas. So what'll happen is if it's, that's what you're going to call the Office of Counsel on that one. Normally you're not directly calling us, you're working up a chain. But if it's regarding that, we want that subpoena that you've received immediately so we can start figuring out was it lawfully issued and what we're going to do. So we're going to work with you. If the Office of Counsel represents us, does that representation extend to potential criminal liability? No, we unfortunately cannot provide advice on a criminal case. So that's why the stuff I don't have time to talk about, which is the ethical code and what state ethics laws, you know, if you're charged with a criminal violation, you're going to have to hire your own attorney. That was an excellent question, and I am out of time. I will just say very quickly, there's a code of ethical conduct that is new. Y'all are the first to get any slides on it. For those of y'all in arts and sciences, I hope to spend some time on that. The main point I want you to know about that is if you complain about any rule or policy violation, whether it's illegal discrimination or not, you are absolutely protected from retaliation, and that's the last paragraph of that code of ethical conduct. I appreciate getting this time with you all. I will be in the back if some of y'all have questions. Thank you.